5 seconds to go. Start. The inner structure was attached by a preliminary order under Section 145 on 29th December 1949 and the receiver assumed charge on 5th January 1950. Reading the pleadings of the plaintiffs as a whole, it is evident that what has been asserted in paragraphs 11 and 23 is not merely an obstruction which was caused to the worship within the precincts of the mosque by the Muslims by the placement of the idols. The case of the Muslims was that the mosque was desecrated and defiled by the installation of the idols. Moreover, the very fact that worship was offered exclusively by the Hindus within the precincts of the mosque after the placement of the idols indicates a loss of possession by the Muslims. An important aspect of the matter is that the events which took place on 22nd and 23rd December 1949 led to the ouster of the plaintiffs from the mosque. Hence, to read the plaint as a plaint which merely spoke of the obstruction in performing worship and not as a complaint against the ouster of the Muslims would be incorrect. In fact, Justice Sudhir Agarwal has, in the course of his discussion, noted that there was an ouster of the Muslims on 23rd December 1949. In paragraph 2439, Justice Sudhir Agarwal observed thus: in the case in hand, the facts pleaded by the plaintiffs show that they were ousted from the disputed premises on 22nd and 23rd December 1949, and the wrong is complete thereon, since thereafter they are totally dispossessed from the property in dispute on the ground that they have no title. The facts, evidence, and oral arguments of the present case have traversed the realms of history, archaeology, religion, and the law. The law must stand apart from political contestations over history, ideology, and religion. For a case replete with references to archaeological foundations, we must remember that it is the law which provides the edifice upon which our multicultural society rests. The law forms the ground upon which multiple strands of history, ideology, and religion can compete. By determining their limits, this court, as the final arbiter, must preserve the sense of balance that the beliefs of one citizen do not interfere with or dominate the freedoms and beliefs of another. On 15th August 1947, India as a nation realized the vision of self determination. On 26 January 1950, we gave ourselves the Constitution of India as an unwavering commitment to the values which define our society. At the heart of the Constitution is a commitment to equality upheld and enforced by the rule of law. Under our Constitution, citizens of all faiths, beliefs, and creeds seeking divine provenance are both subject to the law and equal before the law. Every judge of this court is not merely tasked with but sworn to uphold the Constitution and its values. The Constitution does not make a distinction between the faith and belief of one religion and another. All forms of belief, worship, and prayer are equal. Those whose duty it is to interpret the Constitution, enforce it, and engage with it can ignore this only to the peril of our society and nation. The Constitution speaks to the judges who interpret it, to those who govern who must enforce it, but above all to the citizens who engage with it as an inseparable feature of their lives. In the present case, this court is tasked with an adjudicatory task of unique dimension. The dispute is over immovable property. The court does not decide title on the basis of faith or belief but on the basis of evidence. Stop.